thank you both for wonderful presentations, and thank you for wonderful discussion. And we go on with knowledge, truth, reality, with a wonderful paper of Leora Bilsky, a professor at Tel Aviv University, who writes extensively on law, literature, history, and she'll tell us about international law as a modern Oedipus, the emergence of a right to truth. Please.
Thank you, Nili, and thank you for the organizers for a very interesting conference. I guess the presumption is that everybody read, because you only gave me 15 minutes, and I thought I know half of the audience here didn't have access to the paper, so I didn't know whether to summarize the paper or to raise new concerns. So I don't know exactly what I'll do, but I have both. This is the paper, these are the concerns. Okay, so it's wonderful to come after Ayelet because she's dealing with legal presumptions, which are the idea that law does not necessarily want to know the truth, and that's the starting point for me about the development of the rise of a right to truth. And what I'm doing in the paper is to suggest a parallel reading of King Oedipus tragedy and the case of Argentina dealing with the general's regime and its aftermath. So let me begin, and I'll see where it leads me. So the right to know the truth about human rights violations has emerged in the past 3 decades in various sites of international law. The European Court of Human Rights, the African Commission on Human and People's Rights, and the Inter-American Commission on Human Rights have all recognized in one form or another family members' right to know the truth about the fate of victims disappeared, tortured, or otherwise abused by the government, and the state's duty to investigate human rights violations, in some cases even when prosecution is not likely to result from the investigations. A similar development can be identified in international criminal law, now the preferred mechanism for addressing gross human rights violations. In the special ad hoc tribunals and in the ICC, didactic objectives, the clarification of historical truth, have come to be considered legitimate goals for international criminal law. And more importantly, the search for truth has been recognized as an independent purpose of the criminal trial. This process is connected to the changing status of individual victims in international criminal law. Recent decisions by the ICC affirm the right to truth as a victim's right by referring to the jurisprudence of the Inter-American human rights system. And finally, the clarification of the truth has also emerged as an overriding objective of truth commissions, in particular under the South African model of amnesty conditions upon confession. So we have many contexts in which we see truth is put forth. And what interested me is, even though the different contexts are very different, and what you mean by truth in the different contexts is very different, I see a development towards a universalization of the truth and the forgetting of the different contexts. And I think this is one of the reasons why I turned to Oedipus and its universal reading. So I'm a bit cautious about this universalization of the truth. The literature, scholarly literature on the right to truth generally takes a triumphant tone and sees the increased legalization of the truth as a progressive and positive development that signals increased recognition of human rights norms. The critical literature on international law, on the other hand, presents all human rights discourse as dangerous for politics and does not focus on the specificities of the right to truth. And I therefore came to look for a source or a prism that would allow me to address the complexity and an ambivalence of the right to truth, a prism that would acknowledge the inclination to use the law to reveal the truth in face of a regime's organized lie, but would also convey the tragedy of allowing the truth to become the ultimate and absolute goal of the legal process. So my argument is as follows. I suggest viewing transitional justice, the area of international law preoccupied with legal responses to a legacy of mass violence, as a modern Oedipus, as a field that began its quest to find the truth as part of a more general commitment to the goal of ending the era of immunity and prosecuting those responsible for horrendous crimes, but finished with a right to the truth that, instead of leading to criminal prosecutions, becomes an independent objective in itself and takes primacy over other purposes of the trial. Subsequently, it is recognized as a human right, an autonomous, absolute, and universal right that belongs to victims and their families. So here I turn to the concerns. Why Oedipus? And this is a great opportunity to explore this. First of all, the story that I discuss in Argentina and Oedipus, they have a lot of similarities. We begin with an unprosecuted crime and a family member who pushes the case forward in order to identify the guilty criminal. However, during the search, a change occurs, and what began as a quest for a legal truth turns into a search about personal identity. And these two truths are very different. I also show the turn from communal concerns, the community in the center, to the individual in the center. Finally, and finally, there is a transformation from an instrumental understanding of the truth to an intrinsic understanding of truth as the only goal in and of itself. So these are similar in both contexts. Another reason why I turn to the Oedipus mythos is its universality and archetypal thinking. We all know that Freud based its science of psychoanalysis on the story of Oedipus and made it into the story of every one of us. It was reformulated as the basis of the science of psychoanalysis, but for me what is interesting is the therapeutic language that has been adopted also by the field of transitional justice. In Oedipus, the engine driving the story is the plague. And first, when I read the tragedy, for a modern secular reader, the plague doesn't resonate. Yes, why is this? Why would the plague disappear once you see the truth? Only if you are a religious believer, you would see the connection. But what amazed me was that when I turned to the literature on transitional justice, the same language of plague is everywhere. And the plague is recast now as authoritarian regimes. And the truth is, again, the medicine that would give us democracy, right? And it's a very similar understanding of a plague as something outside there that needs to be cured by the truth. And I challenge this understanding of the plague. And just as psychoanalysis strives to bring the unconscious into the conscious, transitional justice scholarship as well as policymakers assume that the revelation of the truth about the past violence will remove the disease, both at an individual and societal level. Another reason to turn to Oedipus is this, what I said, this moving from a contextual understanding of the right to truth, it's very different in South America, in South Africa or elsewhere, to a universal language of something that, that can work everywhere the same. And anyone who reads the international documents on the right to truth sees it's ahistorical. And it is analogizing the right to truth to torture, to crimes against humanity. So it's, again, atemporal in the sense that there is never a time limitation on its investigation, and there is no in situ. There is no a place in which you should investigate it, because if it's not investigated in Argentina, it can be investigated in universal jurisdiction elsewhere. And so this is this universalization and atemporalization is parallel in the idea of a myth and the idea of this. And it interested me because I think we lose a lot of the dangers that come with it. Finally, two more things. Oedipus myth I read it also as a critique of a kind of scientific knowledge, because the end of the tragedy is this gouging of one's eyes to another knowledge that cannot accept this separation between the subject and the object, but it's internal, inward seeing. And we see similarly in Argentina running away from a political discourse to a scientific discourse of genetic testing that would give us the truth about the identity. It's the same understanding of identity as constant and not relational, and it will give us also the what we should do. The minute we know the genetic examination, the whole society's identity is determined by it, and we don't have to discuss anymore about the route we are going to and so forth. So, and I think that Oedipus shows us the risk of this kind of scientific understanding. And finally, and most dear to me, is Oedipus as thinking beyond a dichotomous or binary thinking about victim and victimizer, about since Oedipus is both the murderer and the victim, and it leads us to think differently about the question of transitional justice, not as identified in the few that are out there that we have to put to trial and be done with, but as a whole society that has to judge itself. And there is no out there. Yes, it's all internal, so we have to come and judge ourselves. And I come to a different autobiography that I read in this paper, in which one of the children of the disappeared discuss. It's a very complicated story, very similar to Oedipus, by the way. So it's this understanding of finding categories that overlap, that does not allow you an identity that is clearly a victim or clearly a victimizer, that is we learn from the tragedy. And I think that the legalization, and especially the criminal legalization, makes us forget about it. And okay, so what can I say about Argentina? So I guess you know the context about Argentina, but I focus about the struggle of the grandmothers. One of the many ways the grandmothers of the Plaza de Mayo challenged Argentina's amnesty laws was to hold military officers responsible for the kidnapping and identity change of the children of the disappeared. According to the organization, over 400 children had been kidnapped by the military, either from their homes or after they were born in detention. Their identities changed and handed over to families of sympathizers with the regime. They argued that because the crimes of kidnapping minors and changing their identities had not been covered by the amnesty laws, they were not blocked from pursuing justice for these crimes. So this is a very clever legal move in order to take away this amnesty laws. The invocation of the right to truth, its classification as a private right of the families of the victims, and in particular its depoliticization in relation to innocent victims, such as the children of the disappeared, helped mobilize the judicial system and ultimately the political system as a whole. However, it did not come free of price. Indeed, the issue of stolen children did not only lead to new prosecutions. In 2009, as the result of lobbying by the grandmothers, legislation was passed to allow the courts to obtain DNA samples from suspected children of the disappeared, even against their consent. And I focus on the Herrera siblings, who, contrary to Oedipus, they were not interested in knowing their biological origins, especially if such discovery could incriminate their mother of being involved in an illegal abduction and adoption. While Oedipus subscribed to a biological conception of identity, they offer an alternative vision of identity, what I call relational identity, and they wrote, "Like so many adopted children, we don't know our biological identities, but like any other person, we have formed our own identities in the course of our lives. We have never seen any concrete proof that we are children of the disappeared. The political use of our stories seems unjust. 34 years ago, our mother chose us to be her children, and we, every day, choose her to be our mothers." So it's this, and of course they were not heard of. The genetic test was taking place. So I identify in the paper two main costs to this kind of right of truth that moved the whole machine. First, in terms of the rule of law. Ironically, a campaign that was carried in the name of restoring the rule of law ended up undermining basic guarantees of the rule of law. As a result of the proceedings surrounding stolen children, criminal justice became a participant in human rights violations. The search for the truth, conceptualized as an absolute autonomous human right, gradually released all restrictions intended to ensure basic civil liberties, status of limitation, the prohibition of double jeopardy, the non-retroactivity of penal law, and consent requirements to infringe on privacy. All of these were put aside in order to investigate this truth. And second, and I think even more important to me, is the cost to politics. Instead of the political community engaging in reflective judgment in order to find a new balance between punishment for past crimes, reparation of the victims, and the establishment of democratic institutions, politics were reshaped as biopolitics, founded upon the search for genetic and scientific truth, with the expectation that this sort of truth would bring certainty and define political identity. I want to end with Malamud Gotti. A decade after the junta trial, Malamud Gotti, presidential advisor to Alfonsine and one of the architects of the trial, came to regret using criminal trials to address Argentina's violent past. In his view, by focusing the blame on the military and obscuring the responsibility of civil society for complicity, criminal trials reproduce the friend-enemy logic of the dirty war and therefore reinforce authoritarianism. It is against this tendency to see the world in black and white that Malamud Gotti wrote his book Game Without End as a warning. The military regime had sought to justify its oppression by depicting the opposition as presenting grave danger to security. It is this good of security in the name of which the rule of law had to be sacrificed. In the struggle against this organized lie, the right of the victims was conceptualized as a right to truth, as absolute and universal, and hence as a good in the name of which the rule of law should be sacrificed again. The story of the Herrera siblings, when read against the story of King Oedipus, allows us to recognize the danger in this tendency and the need to put limits on the conceptualization of the truth as a private human right.
Thank you very much.